Franchise fraud. Franchise fraud is defined by the United States Federal Bureau of Investigation as a pyramid scheme. Franchise fraud in U.S. federal law. The FBI website states, pyramid schemes, also referred to as franchise fraud or chain referral schemes, are marketing and investment frauds in which an individual is offered a distributorship or franchise to market a particular product. The real profit is earned not by the sale of the product, but by the sale of new distributorships. Emphasis on selling franchises rather than the product. The most recent version of the FTC franchise rule was in 2007, is printed in FR 2000 Savina, pp 15544 15575. The FTC franchise rule specifies what information a franchisor must disclose to a prospective franchise business as a franchise opportunity in a document named the Franchise Disclosure Document (FDD). Means of committing franchise fraud. Franchise fraud law in the U.S. state by state. California. California franchise investment law begins at Section 31,000 of the California Corporations Code. Part 1 lists the definitions of the California Franchise Code. Part 2 is the regulation of the sale of franchises. There are 3 chapters, 1 exemptions, 2 disclosures, and 3 general provisions. Under Chapter 2, Section 31,125, the following exists. The proposed modification is in connection with the resolution of a bona fide dispute between the franchisor and the franchisee, or the resolution of a claimed or actual franchisee or franchisor default, and the modification is not applied on a franchise system-wide basis at or about the time the modification is executed. A modification shall not be deemed to be made on a franchise system-wide basis if it is offered on a voluntary basis to fewer than 25% of the franchisor's California franchises within any 12-month period. B. The proposed modification is offered on a voluntary basis to fewer than 25% of the franchisor's California franchises within any 12-month period. C. Any modification of a franchise agreement with an existing franchise of a franchisee shall be exempted from this chapter if the modification is offered on a voluntary basis and does not substantially and adversely impact. If a franchisor shall not make modifications in consecutive years for the purpose of evading the 25% requirements set forth above. If a franchisor in California keeps less than 25% of former California, the modification agreement can have a clause in the document stating that it was signed voluntarily. Part 3 of this code describes fraudulent and prohibited practices. Chapter 1 describes fraudulent practices. Chapter 2 describes prohibited practices. Chapter 3 describes unfair practices. Indiana. In Indiana, fraud, deceit, and misrepresentation during the process of franchise contract formation or performance is actionable at civil law under the Indiana Franchise Act. There is no general right of action, only a specific right of private action by a party on the aforementioned grounds. The scope of franchise fraud is also narrower than the scope of ordinary common law fraud action. The Indiana Supreme Court holds that the circumstances of fraud would be the time, the place, the substance of the false representations, the facts mispresented, and the identification of what was procured by the fraud. However, the plaintiff in a franchise fraud action must nevertheless plead the facts and circumstances alleged to constitute fraud. Also held by the Supreme Court is that scienter is not an element of franchise fraud, nor does failure to disclose on the part of a franchisor a pending civil lawsuit at the time of making a franchise agreement constitute franchise fraud, so long as any such representations as to legal action are not relied upon by either party as part of their decision-making process. Statements by the franchisor as to potential earnings by the franchisee do not constitute franchise fraud, since they do not constitute a material misrepresentation of past or existing facts. Civil action under the Franchise Disclosure Act must be brought within 3 years of discovery of the violation. Action brought under the Deceptive Franchise Practices Act must be brought within 2. Franchise fraud examples. Burgerim. Franchise figures can be misleading, and this was certainly true for Burgerim in 2019, when they had raised at least $57.07 million in franchise fees while many of their franchisors were facing financial ruin. In that same year, the corporation announced bankruptcy and the founding CEO fled the country. Burgerim has already been prohibited from franchise registration in the states of Maryland, Washington, and Virginia, and the state of California fined Burgerim executives for their predatory and dishonest franchise practices. This included failing to disclose in their FDD that the company was going through bankruptcy, concealing the number of cancellations and refunds, mismanaging franchisees' initial franchise fees, bouncing refund checks, and neglecting other franchise obligations. Subway. Although Subway is a major brand name in the fast food and sandwich industry, heavily discounted products and controlling decisions made by corporate has led to the financial ruin of many Subway franchise owners. Subway franchisees have little to no say in many important business decisions, such as in the way that vendors are chosen or prices of goods are set, nor can the franchise owner use its leased premises for another purpose. Through a rigged inspection and arbitration process, Subway capitalized on minor infractions of franchisees. Subway constantly put the benefits of its corporate office ahead of their franchisors, often encouraging Subway franchises to open in close proximity to each other, a practice that Business Insider equated to cannibalizing businesses. Lastly, it was revealed in litigation that one business development agent, BDA, was financially incentivized to report on extremely minuscule and insignificant infractions. Also, Subway corporate could seize back the business. The real profit is earned by the BDA selling and taking over Subway restaurants, not by the sale of the product, but by the sale of new distributorships. Las Quesadillas. On April 13, 2021, the United States Attorney's Office announced a Mexican businessman, his wife, and 2 collaborators were charged with $1 million franchise fraud. The charges allege that from 2015 to 2019, the defendants promoted Las Quesadillas aka Las Cuecas franchise opportunities throughout Texas, including in San Antonio and Houston. Defendants Adriana Pastor and Juan Enrique Kramer were paid $105,000. One Mexican investor even paid $350,000, including a master license for parts of Houston. There is no public evidence that Las Quesadillas is actually a franchise despite being marketed as one. Midi Sai. Starting in 2015, Midi Sai, a pizza franchise, sold more than 500 franchises. However, by the beginning of 2020, locations peaked at 36 units. In summer 2017, there were no more than 7 Midi Sai units open and 170 franchisees signed up to build 1 to 5 units. Midi Sai collected over $8 million in franchise fees in 2016, but paid out over $6.02 million to franchise brokers. Franchise brokers were flown in from across the United States paid for by Midi Sai. "It's a rolling train wreck," said attorney Stephen Green. Instead of building a company store and replicating it, they let their initial franchisees be their test cases. Their estimates on build-out costs, operating costs, and expected revenue were grossly inaccurate. Midi Sai was a sister franchise of Menchie's frozen yogurt.